Okay, so now friends, let us begin with polity. અને પોલિટી જે તમને ખબર જ હશે GS2ની અંદર આવે છે, રાઈટ? અને એનું કેટલું મહત્ત્વ છે એ તો આપણને ખ્યાલ જ છે. હવે પોલિટી જે છે માત્ર ને માત્ર લક્ષ્મીકાંત વાંચવાથી કોઈ પોલિટી પૂરું નથી થતું. પોલિટીની અંદર ઘણું બધું એનાલિસિસ આવે છે અને લક્ષ્મીકાંતની અંદર કોઈ એનાલિસિસ નથી હોતું. એટલે આપણે આ કરવું બહુ જરૂરી છે. ઓકે, અહીંયા બધા સિલેબસની ટોપિક આવશે. અહીંયા જે છે એ બધું સ્ટેટિક પોર્શનને આવરી લેવામાં આવશે. એટલે લાઇનથી લાઇન જશે અને પછી અહીંયા બાકીની બધી જે એક્સ્ટ્રા ઇન્ફોર્મેશન હશે એ બધી અહીંયા આવશે. ઓકે, તો સ્ટેટિક ઇટ ઇઝ ઓલ અબાઉટ કીવર્ડ્સ એન્ડ એક્ઝામ્પલ્સ, ડિફરન્ટ વેઝ ટુ ટોક અબાઉટ ધ સેમ પોઈન્ટ. ઓકે, એકચ્યુઅલી સ્ટેટિક ક્વેશ્ચન્સ આવે ને તો એકને એક પોઈન્ટ્સને 3-4 વાર આપણે અલગ અલગ રીતે આપણે મૂકી શકીએ ને, એ જ આખી આની ઓલી છે, રામાયણ છે. પોલિટી એન્ડ ગવર્નન્સની અંદર અમુક એનાલિસિસ, અમુક કીવર્ડ્સ આપણે પહેલાંથી ગોખી રાખવાના છે, બરાબર? જેમ કે કોઈ પણ કમિશન હોય, જેમ કે SC, ST, OBC, એનું આ રીતે MCP Pro: મોનિટર, કમ્પ્લાયન્ટ, પ્લાનિંગ, પ્રિપેર રિપોર્ટ્સ, recommend, okay, and other matters as president has recommended. તો MCP Pro, okay, monitor, compliant, planning, prepare reports, recommend and other matters. Okay, social audit માટે છે મોરુ: measure, understand, respond and ultimately for the benefits of the community. 5A of health service: affordable, accessible, appropriate, accountable, adaptable. To this, India has added Ayush and Ayushman Bharat. Okay. 6 guiding principles of scheme: ABCDEF: align, believe, communicate, democratize, evaluate, follow through, among others. 4 C's: CVC, CBI, CAG and CAG. So any bureaucrat is fearful of this 4 C's. Okay. Now there are some keywords that actually we substituted by some good words. Okay, good generic words. Corruption: instead of writing there's a large scale corruption, we need to write red tapeism and bureaucratic hurdles. Unavailability of data ની જગ્યાએ lack of or poor data integrity, data availability and data incoherence. Okay, lack awareness ની જગ્યાએ poor social media outreach and legal rights awareness. Conflict between central and state नहीं, federal challenges. Leakage नहीं, siphoning of funds and misappropriation of funds. Lack of transparency and accountability नहीं, power without accountability and transparency or weakening of the accountability mechanism. આ વધારે બેટર રહેશે. ઓકે, lack of skilled labor નહીં, do not have access to qualified learning professionals. ઓકે, પછી સાયલોસેન્ટ્રિક અપ્રોચ. ઓકે, પછી ambiguity in definition and scheme, lack of expertise, capacity, skilled manpower, against the principle of natural justice, quality and informed lawmaking, protecting free expression while fostering tolerance and civility. Okay, nurture transdisciplinary leadership, improve equity and quality in education by administering a research-based, valid, reliable, efficient, transparent, fair and international level assessment. Okay, intersectoral convergence of program, foster efficacy, effectiveness in conducting free, fair, transparent and participatory election worldwide. Evidence-based policy making, policy spillover, democratic backsliding, out of sight, out of mind policy making, maze of law, principle of subsidiarity, regulatory cholesterol, judicial activism, a tyranny of unelected, from episodic accountability to ongoing accountability, need for ongoing accountability versus present ad hoc accountability, crisis of credibility, among others. Okay, other keywords: foster the spirit of competitive and cooperative federalism, adequate, secure, non-lapsable fund, public vigilance, data as a public good, by the people, for the people and of the people, dual morality in politics, pragmatism and ethics of politics. Pragmatism is the ethics of politics. 360-degree profile of individual, simplification of procedures, incentivizing performance, red tape reduction, study now, pay later model of education, learning poverty, that is a percentage of 10-year kids who cannot read or understand simple stories, process driven and professional governance. Panchayati Raj institutions from bureaucracy led developmental model to people led developmental model. Panchayat driven social sector expenditure model. Panchayati Raj is a half baked cake. Okay. Accelerating mega programs and services. Spirit of autonomy for CBI. From welfare to development to empowerment. Apathy and lackadaisical attitude of administration is unpardonable. Okay. So you can use such keywords. Administrative justice, PIL misuse, 3 Ps, private, political and publicity. Judicial restraints, bill of national importance, raise his or social consciousness, legally prescribed and judicially settled parameters. Okay, you can use this in anti-defection. Reformative justice, decentralization of corruption. Reformative justice, decentralization of corruption. Sarpanch Raj, nexus of bureaucrats, sarpanch and politicians. Bipartition of involving the agreement or cooperation of two political parties that usually oppose each other's policies. Okay, this is a bipartisan support for Model Code of Conduct. Information, education and communication material. Adversarial legal system to inquisitorial legal system. Improving public trust. Effective leadership at the top. Contribution to policy failure. Overly optimistic expectation. Implementing and dispersed governance. Inadequate collaborative policy making. Vagaries of political cycle, archaic rules and law, cooperative and collaborative federalism, cooperative and competitive federalism, centralized, confrontational, cooperative, competitive and cooperative, collaborative, creative, constructive, converging and federalism. Okay, you can utilize any of these terms. Centralized, confrontal versus cooperative, competitive, okay, collaborative, creative, constructive, converging. Okay, decentralization, debureaucratization, delegalization, delegation and democratization, 4 Ds of Panchayati Raj institutions. From top down to bottom up approach. Okay, formal democracy to substantive democracy, or you can say procedural democracy to substantive democracy. Trusted steel frame to rusted steel frame for bureaucracy. Okay, so these are the keywords. Talking about Indian Constitution. Okay. Silent features. What are the silent features? It is the lengthiest. Yes. Number 2. Silent features of the Indian Constitution. It is written, drawn from various sources. Blend of rigidity and flexibility. Drawn from various sources, you can name British Government of India Act 1935, Canada, USA, right? You know the examples. Blend of rigidity and flexibility, Article 368. Okay. Parliamentary form, federal system with blended unity. Okay. Yes. So where were we? A blend of rigidity and flexibility. Parliamentary form. Yes. Federal system with unitary bias. Integrated judiciary. Fundamental rights. DPSP. Secular states. Universal adult franchise. Single citizenship. Independent bodies. Emergency provisions. 3-tier government. Cooperative societies, among others. So these are the silent features. You can see that there are how many points? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16. So you can say that there are 16 silent features of the Indian Constitution that should come if you write an answer. Okay, what are the criticisms? It is a borrowed constitution, un-Indian, un-Gandhian, elephantine science, paradise of lawyer, a carbon copy of Article Government of India Act 1935. So how to remember this? So there's a trick called FOJPIA. So federal scheme, Office of Governor, Judiciary, Public Service Commissions, emergencies and administrative details. Okay, so you can use this carbon copy, FOJPIA. So Constitution is not merely a lawyer's document, it is a way of life, Dr. B.R. Ambedkar. So you can conclude with this. Okay. Okay, moving on. Fundamental rights. and constitutional plus constitutional amendments. So this is very important topic. Okay, exceptions, acquisition of estate, etc. Article 31A, validation of certain acts, regulations, Article 31B, and 9 Schedule DPSP 31C. Okay, criticisms, excessive limitation. Number 2, no social and economic rights, no clarity, such as public order, minority, reasonable restrictions, public interest. So these are not there is no clarity on it. Okay, no permanency. A right to property is removed in 1978. Yes, suspension during emergency. Okay, I'll give 3, 4, 5. Suspension during emergency. Yes, we have very expensive remedies that you need to go to Supreme Court or High Court. Preventive detention, Article 21, 22, is also part of the fundamental rights, which is very dangerous. No consistent philosophy, it creates difficult to interpret. Okay. Rule of law, Avid ICS said, absence of arbitrary power, equality before law, and primacy of right of individuals. Okay, so in case of India, there is an absence of arbitrary power. Yes, the equality before law, there is an exception, such as precedent in Article 361, that anything he has done in his office cannot be called a question. Okay, so he is above law. Diplomats, number 2, UNO, number 3, publication of true report proceedings of the House, Article 360A, number 4. Okay, yes, so 4 things are exempted from equality before law. Primacy of right of an individual. So constitution is a source of individual right in case of India. Here 2 privileges are there, which is again Article 105, 194, law made to implement DPSPs. Okay, Article 39B, C, Article 31C. Okay, Article 15 and 16, reservation, historical injustice, socio-economic backwardness, exclusion, and underrepresentation. Okay, Indian scheme of reservation, there are spheres. So public education, yes, Article 15 plus 4, 15 plus 5, 15 plus 3, 46, 15 plus 6. Public employment, Article 16 plus 16 plus 6. Private education, yes, 97th Constitutional Amendment Act 2005. For whom? SC, it is about 16.6. ST, it is about there are about 720 tribes. Okay, OBC, after Mandal Commission's recommendation, he used the basis under the 1931 census, and women's. Okay, even now the 5th criteria is EWS. So yes, my friends, the reservation is increasing. You better get selected very soon. Okay, what are the rationale? The strongest form of affirmative action, yes. And unemployment, number 2. Underdevelopment, number 3. Agrarian distress, yes. Reducing income disparity. Wealth transfer to lower caste, number 6. Balance of equality, number 7. Efficiency and social justice, number 8. Okay. Okay. What are the challenges? Cases are caste, I beg your pardon. Caste as a sole criteria, revitalization of caste identity, rise of losing all other forms of non-reservational notions of equality, prolonged period, and class within caste. Yes, so these are the major issues with the reservation policy. Article 19, we have so MRP, freedom of speech and expression, assembly, union or association. We have the movement. Okay, reside and profess. Okay, so MRP. Yes, you can remember this. Why preventive detention is also being provided? So for maintenance of law and order, colonial relic of the past, public safety and societal stability, crisis of implementation, advisory board to check vagaries of the executive. So yes, we have enough checks too. Okay, so you can write that this is the why we have preventive detention. But what are the issues? The political tool. It is used against the spirit of law. questionable performance of advisory board, establish board jurisprudence on a lawless law. Okay, so we do not have any law for this. So yes, 1, 2, 3, 4, 5, 6. Okay, there are 6 points. Sedition, again, sedition came in Thomas Macaulay in 1837 and it brought this sedition law. Today, IPC section 124, any person by word otherwise brings an attempt to bring into hatred or contempt or excite or attempt to excite dissatisfaction or disaffection towards government by word, sign or visible representation is a cognizable offense. Okay. Cognizable, non-bailable, non-compoundable, very serious offense. Favor, it leads to unity, stable polity, power of contempt, public order, and Kedarnath case too, it was well settled. So legally settled and parliamentary prescribed, legally prescribed and judicially settled. Okay. What are the against? The Law Commission of India has written that citizen FR is hampered, ambiguity and misuse, COVID restrictions, low conviction rate, yes. Internationally, international conventions such as civil rights and political rights, we are signatory to this. UK, Australia and US, such countries have also removed the seditious law. Okay, way forward, we need a clear definition, procedural safeguard, use sparsely and scrutinizing committee. Yes, okay. Right to life and liberty, Article 21. एक ही गोपालन, triple taste, that there should be a law. What it means that, I beg your pardon, Article 21, right to life and liberty, unless procedural established by law. Okay, so in initial phase it was this, that yes, if there is a procedure established by law, then it could be a triple test. In A.K. Gopalan case, there should be a law that should be made by a competent authority, and procedure of the law should be followed. So procedural established by law means only these 3 things. However, in the Menka Gandhi case in 1980, I think 1980 or 88, they changed to effectively due process of law. So triple test of Gopalan plus law should be just, fair and reasonable and non-arbitrary. So in a way they made it a due process of law, that it should be just and reasonable and no arbitrary action by even legislature. Okay, so legislature too cannot take your life arbitrary. Okay. Expansion of Article 21, yes. Right to those under detention protection homes, yes. Sunil Batra case. Access to justice, Hussein Khatun case. Right to die, Gyan Kaur case. Right to health, Paramanand Atara case. Right to clean environment, MC Mehta versus Kamal Nath. Virendra Gaur case, Bhopal case, tragedy case, yes. Right to food, POCL versus Union of India case. So this can be a question in the near future. Okay, so it has not been asked, it can be asked. Right to privacy, Pegasus, we have Puttaswamy case 2017, yes. So most of the things have already been asked in privacy, so I don't think so that we need to go into much details of this. Okay. Only we need to know is that in Puttaswamy case, they have struck the right balance, that privacy is an enabling right which is required for other rights. બીજી રાઇટ્સને એન્ટરટેન કરવા માટે આપણને આ રાઇટ્સ તો જોઈએ જ, પુટ્ટાસ્વામી એટલે પ્રાઇવસીની રાઇટ્સ જોઈએ જ. ઓકે, જેમ કે તમારી પાસે જો પ્રાઇવસી જ ના હોય તો તમે ફ્રીડમ ઓફ સ્પીચ એન્ડ એક્સપ્રેશન કઈ રીતે કરી શકશો? તમારી જો બધી વસ્તુને જો થતી હોય તો રાઇટ ટુ બી ફોરગટન, yes. Ability of an individual to limit, delink, delete or correct the disclosure of personal information on internet that is misleading, embarrassing, irrelevant or outdated. Okay, so this is the definition of right to be forgotten. Karnataka High Court has given right to be forgotten in 2017. Notable Jeopardy, every sinner has future, yes. BN Sri Krishna Committee, has also mentioned about this. Okay. Right to internet, Fahim Shirin was case in 2019. Third generation right focuses on collective development. Okay, right to internet. Internet index freedom, we are ranked about 51, which is very low. Enabling right, yes. Right to trade through internet is also fundamental right. Does not qualify. What are the criticisms? Not qualify as human right. Feasibility for developing countries is very limited. Okay, digital divide is very high. Reasonable restrictions can be applied. Misuse of internet for drug trafficking, terrorism, human trafficking, arms smuggle, drug smuggle, among others. Okay, and it is again a urban concept, right? So usually, you do not have many problems in the rural regions. ग्रामीण क्षेत्र है, कोई ना कोई फर्क नहीं पड़ता अवस्थिति. Okay. Article 32, right to the constitutional remedy. B.R. Ambedkar has pointed out the very heart and the soul of the constitution. Former Chief Justice Gajendra Gadkari has said that it is a cornerstone of the edifice of constitution. Okay. What is its importance? Protection of individual liberty, doing effective justice, disallowing excess of jurisdiction, addressing the error of law, undoing illegal or wrong use of power, enabling court to do justice, and judicial innovation. Yes, these are the importance. And then there are other importance too that cannot be neglected. Okay, what are the challenges? Tribunalization of justice, critical issue, judicial overreach. Sedition we already seen in the above factors. Okay, Gandhi called it a price of all law that chokes liberty. આપણે એક સેડિશન ઉપર તો ઓલરેડી કામ તો થઈ ગયું છે, આઈ થિંક વાતચીત થઈ છે. ઓકે, આપણે જ્યારે 19 કરતા હતા ત્યારે હતું. ઓકે, પણ આપણે પાછળથી પણ એક સેડિશનનું છે તો જોઈ લઈએ. ઓકે, national unity and objective national unity and integrity, prevent radicalization and extremism, legal tool to bring anti-India elements to book, address hateful effort that might lead violence. Okay, issues શું છે? Chilling effect on freedom of speech and expression, low conviction, processes punishment itself, social shame, criminalization of dissent, and disproportionate punishment, colonial relic of the past. Okay, so you can go in the stakeholder way. Way forward, view Kedarnath judgment in legal scheme. Okay, proximity test, clear nexus between speech and consequent violence. So there should be a proximity test too. Okay, censorship refers to suppression or prohibition of any content or part of context, book, text, newspaper, movies that are obscene, objectionable, politically unacceptable, or threat to security of states. Okay. Cinematographic Act 1952 provides for the certification of Central Board of Film Certification. Issue again in chilling effect on freedom of speech and expression, arbitrary standard of offense, truth, costly and time-intensive litigation, burden of proof, and economic burden. Okay. Doctrine of basic structure. Significance: constitutional amendment without defacement of its identity, preserves the democratic polity, win-win for parliamentary power to amend coexisted with judicial review, increase checks and balance. Issue एक तो authoritative study, yes, inordinate power given to unelected judiciary, exclusive power of parliament to make law, length of judgment creating conceptual confusion over the doctrine, judicial activism, attempt to rewrite the constitution. Yes, okay. Well, in the end conclusion, you can quote Upendra Bakshi, who calls the doctrine of basic structure as the savior of democracy in India. Reference document for Bangladesh court too. So even Bangladesh court judiciary has used this basic doctrine of basic structure as a reference document. Now let us see some of the amendments that are very important and brought to the constitution. The first is 9th schedule. Third is parliamentary control, production, supply and distribution of foodstuff. Okay, so you need to remember this. compulsory for president to assent constitutional amendment bill. Okay, 33. Speaker may accept the resignation if he finds that the resignation given by MP or MLA is under undue pressure. Okay, 42nd. Again, this is very important. We have the preamble. We added socialist, secular, and integrity. Fundamental duties, Swaransham Committee, Tribunals, Article 323 and 323A. DPSP, we added 39A, 43A, this is for free legal aid. 43A is to bring workers in the management of the company. 48A is for environment and for the wildlife, environment, forest and wildlife. Okay, 5 subjects, northeast and part of territory. Okay, 5 subjects in concurrent list. Okay, did away with quorum. So these are the amendments to the constitution. 43rd was jurisdiction of SC and HC, judicial review and writ powers. Okay, 44 press protection, armed rebellion, written recommendation of cabinet, delete right to property, fundamental right, article 20 and 21 cannot be suspended even during the emergency. Okay. 52nd constitutional amendment is anti-defection. We will study about anti-defection. Okay. We have 21A is 86th constitutional amendment act. 89th is 30 separation of National Commission for SC and ST. Okay. 91st is again anti-defection amendment. 97th is cooperative. 101 is GST. So we need to remember this. 103 is EWS. And the last is 106, which is women reservation, which will come in the relevant sections. Okay. Okay, so that's the salient features. Let us look into the preamble. Introduction. Dr. B.R. Ambedkar calls the preamble as the yardstick to measure the worth of the Constitution. Okay. It is the horoscope of sovereign democratic republic. You can use this as a conclusion. Okay. Embodies fundamental values and philosophies, grand noble vision. Ernest Barker says that the preamble is a keynote to the Constitution. Okay. Significance. It reflects the source of authority, we the people. Reflects the nature of state, that is sovereign, socialist, secular. Okay. Guide to unlock the minds of constituent assembly. Yes. Guide in transformative judgment. State about the nature of state. Philosophical foundation. Founding moment of the Constitution. Yes. So these are the significance. Number we have 1, 2, 3, 4, 5, 6 and 7. Okay. Sovereign. Let us now dwell into each of these words. Okay, sovereign. The word sovereign implies that India is neither a dependency nor a dominion of any other nation, but an independent state. It implies absolute independence. Article 395 is repealed. Yes. Independent state without authority above. Okay, Article 1, India, that is Bharat. Free to conduct its own affair, frame its own policies. Article 368, and formulate foreign policies. Socialist. The Indian brand of socialism is a democratic socialism. Okay, 42nd Constitutional Amendment Act brought socialist into the preamble. Faith in mixed economy where both public and private sector coexist side by side. Indian socialism is a blend of Marxism, Gandhianism, and leaning heavily towards Gandhian socialism. Okay, democratic socialism, Gandhian plus Marxism. Mixed economy, welfare state, DPSP provisions, end poverty, hunger, reduce inequality, and key welfare schemes can be seen that India as a democratic socialism. However, in 1991 LPG reforms, a retreat of state, disinvestment, and service delivery to the private sector shows that cast dark clouds over the socialist credentials of Indian democracy. Okay. Secular Indian Constitution embodies a positive concept of secularism, that is, all religions of our country, irrespective of their strength, have the same status and support from the state. Sarva Dharma Sambhav is what is part of this. 42nd Constitutional Amendment Act brought secular. Yes, India is neither a religious and nor anti-religious or irreligious. Gandhi has said that Sarva Dharma Sambhav. Nehru, principled equidistance, and Dr. B.R. Ambedkar, protection of minorities. And ultimately, S.R. Omai case, wherein 1984 the judiciary opined that secularism is a part of basic structure of the Indian Constitution. Provisions, what are the provisions? Preamble, we have citizenship, Article 5, which gives citizenship to anybody irrespective of caste, sex, religion, place of birth. Article 14, equality. Article 15, based on caste, sex, religion, unemployment. Article 16, 25, 26, yes, religious rights. 27, 28, educational and educational and minority rights. 29, 30, about culture. 44, Uniform Civil Code, Universal Adult Franchise, Article 326. So these are the provisions of secularism. Then you can say that India has a secular credentials because of these articles in the Constitution. Okay, democratic, yes, based on the doctrine of popular sovereignty, that is, position of supreme power by the people. Representative parliamentary democracy. Okay, Dr. B.R. Ambedkar can say that political democracy cannot last unless there lies at the base of it a social democracy, a way of life which recognizes liberty, equality, and fraternity. The principle of liberty, equality, and fraternity are not to be treated as a separate item, rather it's a trinity. Broader sense, social, economic, and political. Yes, we are political democracy, social democratic, and economically democracy. Okay. Justice. Justice, as per John Rawls, is fairness. Okay. Substantive, morally justified, and procedural justice is fair and impartial procedure. By applying trinity of liberty, equality, and fraternity, we aim to achieve substantive justice. Justice, that is ordering of society, is centered. Okay. Social justice it denotes the equal treatment of all citizens without any social distinction based on caste, color, race, religion, sex, or so on. Okay. Economic justice, it denotes non-discrimination between people on the basis of economic factor. It involves elimination of all of glaring inequality in wealth, income, or property. A combination of social justice and economic justice denotes what is known as distributive justice. Okay. Political justice implies that all the citizens should have equal political rights, equal access to all political offices, and equal voice in the government. Okay, this is political justice. Liberty means the absence of restraint on activities of individual, and at the same time providing opportunities for the development of individual personality. Okay, this is liberty. Again, liberty means absence of restraint on the activities of individual, and at the same time providing opportunities for the development of individual personalities. And so it should be providing equal opportunity for the development of individual personality. Okay. Equality means the absence of special privileges to any section of the society and the provision of adequate opportunities for all individuals without any discrimination. There are three dimensions of equality. The civic equality is under Articles 14, 15, 16, 17, 18. Yes. Political equality, Article 325, 326, which is right to vote. Economic equality, Article 330, Article 39. Okay. Redistribution of wealth. Equality may be fiction, but nonetheless one must accept it as a governing principle. Okay. Dr. B.R. Ambedkar. So you can quote Dr. B.R. Ambedkar anywhere. Now let me for a moment revise this. Okay. Equality may be fiction, but nonetheless one must accept it as a governing principle. What do we civic equality, political equality, economic equality? Okay. So I make one. Fraternity. a sense of brotherhood, single citizenship, Article 5, a fundamental duty, Article 51A. It is a dignity of an individual, unity and integrity. So, by fraternity, what we are trying to ensure is the dignity of individual, unity and integrity. Okay. So, whether preamble is a part of constitution. Okay. Okay. Sorry. I beg your pardon. So, we have Bakil. Okay. Berubari, Keshananda Bharti case and LIC case. So, yes, preamble is the part of the constitution. Birubari case 1960. Key to unlock the minds of the constitution maker. Keshananda Bharti case 1973. Grand and noble vision expressed in preamble. LIC confirmed it once again. Okay, 1995. So this is it, preamble. Now let us dwell into DPSP. Okay. DPSP starts with Article 36 to 31. It was Irish Constitution, instrument of instruction. Yes, Gandhian. So that it can be divided into Gandhian, socialist, and liberal. Let us begin. Number one is Village Panchayat Unit of Self-Government, Article 40. Cottage Industries, Article 43. Cooperative Society, Article 43B. Education and economic interest of SC, ST, and other weaker sections to protect social injustice and exploitation, Article 46. Okay. 43, 40, 43B, 46. Prohibition of use of intoxicant drug, Article 47. Prohibit slaughter of cow, Article 48. Socialist justice, social, political, economical, and to ensure minimizing of inequality, income, status, facilitate facilities and opportunities, Article 38. Equal justice and free legal aid, Article 39A. Secure rights to work, education, and public assistance in unemployment, sickness, and disablement, Article 41. Just and human condition of work and maternity relief, Article 42. Securing a living wage, Article 43. Okay. Participation of worker in the management of industries, Article 43A. Raise standard of living and level of nutrition and improve public health, Article 47. So Article 39 has 6 different categories. Number one is adequate means of livelihood, equitable distribution of material resources, prevention of concentration of wealth and means of production, equal pay for equal work, preservation of health and strength of the children against the forcible abuse, opportunities for healthy development of child. Okay. Liberal intellectual, we have 44, Article UCC, early childhood care and education until they complete the age of 14. Okay, Article 45. Organize agriculture and animal husbandry, Article 48. Protect and improve environment to safeguard forest and wildlife, Article 48A. Protect monuments, places and objects of artistic and historical interest, Article 49. To separate judiciary from executive and public service of state, Article 50. Promote international peace, security and maintain just and honorable relation between nations, Article 51. Okay. So let us talk about Uniform Civil Code in brief. So it could be the potential question in the near future. So Uniform Civil Code is under Article 44. Okay. It states that there should be a common code, a common uniform code irrespective of caste, sex, religion, place of birth for personal to manage personal relationship. What are the personal relationship of marriage, divorce, adoption, and inheritance? Okay. Need social, political, administrative, and ethical. Okay. What are the needs? Constitutional ideology. Why there is a need? Why there is a need for uniform civil code? Okay. The constitutional ideology, address to inherent contradictions. Okay. Untangle legal judicial complications, odd with fundamental rights such as triple talaq, gender empowerment, eliminate inconsistency in law, okay, inconsistency within region such as Pondicherry, Goa, Nagaland, yes, so yes, national integration, okay. Again, what are the criticism? So unity is not uniformity. Law Commission in its 277th report pointed out that it would be an arduous task, okay, against quintessence of democracy. So if we try to actually impose, it would be against the democratic principles. UCC is not a panacea, yes, okay. Politicization of issue, imposition on minorities, and piecemeal approach, okay. Directive outside Article 40, Part 4 of the Constitution. Right? What any is there any directives? Yes, Article 335, claims of SC and ST for the service, instruction in mother tongue, Article 350A, Hindi, Article 351. What are the criticisms of all overall DPSP? It's no legal force, illogically arranged, conservative, constitutional conflict, limitations of states' capacity, inherent contradiction of DPSP, regulating animal slaughter versus economic justice, conceptual confusion with fundamental rights. What is the utility? Yes, we do still, despite all this criticism and despite it being a non-legal injustice evil, it has its utility. So what is its utility? The instrument of instruction, beacon light of court, dominating background to all states' action, amplify preamble, stability and continuity, supplementary to fundamental rights, enable opposition to exercise influence and control, test for performance, and common political manifesto. Okay. When it comes to fundamental rights versus DPSP, fundamental duty versus DPSP, okay, let us see. Negative in approach, political and socio-economic, okay. It is, I think, fundamental rights, I beg your pardon. Okay. Wait a minute. Okay. The first is that fundamental rights are negative in approach, while DPSP is positive in approach. It is about political rights, political and civic rights. It is socio-economic rights. Legal versus political, yes, again. Promote welfare of an individual, personal and individualistic versus welfare for community, societarian, okay, socialist. FR is automatically enforced, and DPSP is not automatically enforced. And again, court can declare law as invalid. However, in case of DPSP, it cannot. DPSP in action, there are many laws that has already been implemented. Okay. Article 39A is for Manrega skill development. Yes, reduce the concentration of wealth. Okay. 40 is 73rd and 74th Constitutional Amendment. 41 Sarva Shiksha Abhiyan education. 43 Wage Act. 47 Health Nutrition PMJ. So there are many actually acts. Okay. For 49 we will say that Wildlife Protection Act. 40, 48, 49 we have Ammasar Act. Okay, for preserving the monuments. Okay. So again, you can raise that Granville Austin has said that DPSP are the conscience of the Constitution. Okay. Fundamental duties. What is the trick? National Institute for Science student bought chemical for testing on plants and environment. So this is just a trick to remember. If you want to remember this, then you can remember this, or else you can actually think of fundamental duties, and we'll try to cover it in the next lecture. Okay. So yes, thank you. I think Indian Constitution is complete. Next time we'll go for comparison of Indian Constitution, and slowly we'll finish all the topics of polity. Okay. So yes, thank you.